The Committee on Finance, Insurance, and Consumer Protection is called to order. Will the clerk please call the roll?
Chairwoman Cavanagh.
Here.
Senator Irwin.
Here.
Senator McCann.
Present.
Senator Bayer.
Here.
Senator Camilleri.
Here.
Senator Heisinger.
Here.
Senator Tice. Senator Daly.
Here.
Madam Chair, you have 7 members present. There is quorum.
Thank you. I will now entertain a motion to approve the meeting minutes from June 20th, 2024. So moved by Senator Irwin. Hearing no objection, the minutes are adopted. I will now make a motion to excuse absent members. Without objection, the motion carries. So we have a couple large bill packages today, and so first, I do want to say that we will be looking at time. I do want to be respectful for everyone's time, and we want to get through them as succinctly as possible. So please don't take my cutting off as rudeness, but just a guidance in the timing direction. First, we will begin with Senate Bills 1021 and 1022, brought to us by Senator Singh. Senator, can you please come forward to explain these bills for committee? And thank you for being here today.
Thank you very much, Madam Chair and members of the committee. I'm honored to bring these bills in front of you for a number of reasons. When I was growing up, Michigan was known as one of the states that had one of the best consumer protection laws in the country. And I started my professional career working at a group called the Michigan Nonprofit Association, and we did a lot of work with the Attorney General's office. Our charitable trust division was underneath the late Stuart Freeman. He was focused over the consumer protection area, and I remember when these laws changed in 1999 when Smith versus Globe Insurance changed the way we did work under the Michigan Consumer Protection Act. It basically gutted our Consumer Protection Act and said anything that was regulated by some other part of state government could not be brought forward under Michigan's consumer protection laws. And that has, I think, unfortunately hurt us. I think all the way back in 2018, national consumer protection groups had talked about the two worst states for consumer protections. It was us and Rhode Island. And Rhode Island actually, since 2018, has actually changed their laws, and we're now the worst in the country. You've seen this in other types of legislation. We're the only state for the longest time to have pharmaceutical companies exempt from liability. We fixed that, and this is another thing that I think we need to fix. You'll hear from the Attorney General's office as well as others on the more specifics of this bill. I want to just talk about a few items specifically here. One is you'll hear from groups saying, hey, for the last 25 years, we've been exempt because basically these laws were gutted. But all of these industries work in other states. And all 50 states have consumer protection laws that are already on the books. Most of those states are in line with what we are proposing here. And so their industries have survived and done effective work in those existing laws. And so as you go through this, I would love for you to take a look, and as you examine other states, you don't have to go too far to go to Ohio and Indiana and see their consumer protection areas, and some of the things that we're proposing here are exactly the same within those states as well. But we wanted to broaden this to remove this sort of exemption from those that have regulatory control of another department. We want to make sure that those that are specifically going after seniors and vulnerable adults are impacted by this. We want to make sure that those that are doing educational work as well as nonprofit work are also now provided under here. This also provides the Attorney General with the authority to use investigative demands, so they don't always have to go in front of a court, but they can do that through their process. That is often found in many other states, including Ohio. And this allows the conversation to be confidential, but at the same time be able to protect the consumers who feel that they have been wronged. Also, it creates a consumer protection and antitrust revolving education fund. I know the Attorney General's office will speak more to that. Again, Ohio and Indiana have this. A lot of the regulatory issues we're asking to be brought back under consumer protection already exist in other parts of the Attorney General's office, whether that's going after Medicaid fraud and other types of areas. So what we're trying to do is align our consumer protection to other parts of the department and the powers that they already have, but then also put us in line to what the true intention of the laws were that were created in the 1970s under Attorney General Frank Kelly. Last thing I would like to say is we are going after people who are actively creating fraud and trying to take advantage of people. And that's what these laws are meant to protect. Our citizens who are actively being opposed. If somebody is doing their business in their normal fashion, they're not breaking the law, This will never impact that industry, that association. So we're going after fraud, and that is really the key fundamental part of this. And so, Madam Chair, I know you have a lot on your agenda. There's other people who speak to the specifics. I'll stop my comments here, answer any questions. I look forward to working with the committee as this unfolds.
Thank you, Senator. Any questions? Senator Camilleri.
Thank you, and thank you, Senator, for bringing these bills forward. I'm very excited to be having this conversation. I'm just wondering if you could talk a little bit about any potential examples of instances in which consumers would be able to utilize this new law, just to give a concrete, idea so that we can think through the real implications of it. One thing that comes to mind for me is all of the fraudulent businesses that took place during the COVID pandemic. And people were hawking products that did not work to protect people's health, but there was nothing that people could do once they found out that those things did not actually help mitigate the COVID-19 pandemic. Are there other things you're thinking about when it comes to this?
Sure. I mean, it's almost any industry, because right now, most industries, because they're regulated under a different department, are exempt from here. So if you had somebody who was actively trying to defraud you on building your house and they didn't actually finish it, there's less tools at the Attorney General's office for you. I think you all know, and many people in this room are watching the Supreme Court case with Eli Lilly versus the state. That is another example of this type of consumer protection that is needed here. And I think your example of what has happened during the COVID is just a prime example of why you need these types of laws. Again, we're not asking for anything new. We're asking for us to go back to where the standards were before this Michigan Supreme Court case, put us in line with other states across the country, red and blue states across the country.
Thank you, Senator. Senator Huizenga.
Thank you, Madam Chair, and thank you, Senator Singh, for your testimony today. Can you give us some examples of active fraud that the Attorney General is not able to prosecute or handle right now, and what sort of tools would be put in place, and maybe just an example of where they are unable to process or prosecute a case like that?
Yeah, Senator, as you know, the Attorney General will be testifying along with her staff, and I'll let them best address the tools that they need that they don't have that other states do have.
Thank you.
It's actually a perfect segue. Thank you, Senator.
Thank you.
We do have Attorney General Dana Nessel on Zoom with us, as well as her staff, Ashley Steffen and Jason Evans, the Legislative Liaison and Corporate Oversight Division from the Attorney General. Thank you for joining us, and take it away.
Thank you. Good afternoon, everyone, and Chairwoman Cavanagh and everyone else on the committee. I am excited to appear virtually before your committee today and to ask you for your help, to help me and help my office, but most importantly, to help the millions of Michigan consumers who stand legally helpless against predatory, deceptive, and unaccountable commercial operators because of devastating misinterpretations of our once all-powerful Michigan Consumer Protection Act. Passed back in 1976 with significant bipartisan support, signed into law by Governor Milligan, the Michigan Consumer Protection Act was once the envy of consumer protection efforts all around the nation. It prohibited more than 30 types of conduct as unfair and deceptive practices in trade or commerce, such as flagrant misrepresentations, exploiting vulnerable customers, and price gouging. This law was badly needed then, and for reasons I'll explain more fully, Senate Bills 1021 and 1022 are just as, if not more so, desperately needed today. A powerhouse Consumer Protection Act, an incredible defense of Michiganders in the marketplace, the Consumer Protection Act supercharged the efforts of the late, great, eternal General Frank Kelly, who in 1962 established the first state attorney general consumer protection division in the nation to ensure Michigan consumers were treated fairly and justly by unscrupulous business interests. But of course, 1962 and 1976 were a long, long time ago. Further towards the beginning of Frank Kelly's nearly 40 years as our state attorney general, and by the end of his time in office, the law and the landscape of justice for consumers looked very, very different. And the grotesque emasculation of the Consumer Protection Act was perhaps the greatest professional disappointment in the life of the Attorney General. Began in 1999, the year he officially left the office that I now hold, when the Michigan Supreme Court issued its ruling in Smith v. Globe Life Insurance, and gutted the act by wildly expanding a narrowly written and surely narrowly intended exemption within the law for transactions or conduct authorized under state or federal regulations in clear conflict with the common sense intent of the lawmakers who authored the act. And then, doubling down on the court's destruction of the Michigan Consumer Protection Act in the next decade, they ruled in 2007 that residential builders were exempt from the act. The practical implication of this holding applies to home improvement contractors and all other businesses licensed under the Occupational Code and other laws, meaning they were likewise exempt from the investigation and enforcement powers of the once mighty Michigan Consumer Protection Act. And the court didn't just change our protections, it rendered the act largely toothless and ineffective against any predatory conduct when the perpetrating business or individual belonged to a professional licensed by a state or a federal agency, essentially providing a free pass for misconduct under the act, regardless of how egregious that act may be. And the court ruled that these essential consumer protections should not apply to the customers of a licensed professional, and in doing so, turned a professional or occupational license into an all-powerful shield against civil accountability for an untold number of customer abusers. Frank Kelly said in response to these decisions, if every person or business which engages in an activity authorized by some statute or regulation were exempt under the Michigan Consumer Protection Act, then it would be a cruel hoax on the many legislators and others who sought to give Michigan consumers protection in the marketplace in the first place. Now, I ran for this office on a platform of including restoring robust consumer protection efforts to the Department of Attorney General. Our consumer protection team helps thousands of Michiganders every year when desperate, deceived, defrauded customers call my office distraught over the way they've been preyed upon by an unscrupulous business operator. It's tireless and endless work to seek justice for these people, and as much as I'd like to regale you all with the successes of my consumer protection team, these are not the callers I'm here today to talk to you about. Tragically, we constantly, and I mean daily, receive countless customers from callers that will find no help from my office. People that we have to turn away and tell them there is simply nothing we can do for you because the person who victimized you and devastated your finances, maybe for the pay period or for your lifetime, as you work to recoup your family's life savings with professionally licensed or works in a field that is otherwise regulated. To this day, my office remains powerless to investigate or hold accountable deceptive business practices such as a grocery store price gouging its community over milk, eggs, and baby formula because grocery stores are licensed as food establishments by MDART, or a used car dealership making deceptive misrepresentations about the vehicle that you forked over your savings to buy, or forcing customers to sign deceptive sales contracts or that it contain illegal clauses because car dealerships are licensed by the Michigan Department of State. A contractor constructing or remodeling your home who made zero progress in months or whose material costs keep mysteriously rising on you because builders are licensed and regulated by LARA. An HVAC company whose furnace repair specialist left your family shivering at night under all the blankets in your house, and he was better at taking your money and making promises than actually fixing things because HVAC contractors are regulated by LARA. Or, in the case that Senator Singh mentioned, a drug company, a massive billion-dollar price gouging drug corporation who's squeezing households to afford basic, necessary medications like insulin and other prescription medications, all because the Federal Food and Drug Administration once approved those drugs for safety, and now there's nothing we can do about it. And we're also proposing to extend the Act's protections to small businesses. Such businesses are ultimately run by consumers, so they are just as vulnerable to being lied to and price gouged as all the rest of us. And when a person's just trying to feed their family by making a living through a small business, my department should be able to do what practically every other department in an AG's office in this country does. They should be able to jump in and help when someone out there is trying to prey upon such persons. And this is just another example of protections available to residents in practically every other state but not here in Michigan. Today, as every day of my time as Attorney General, and when Bill Schuette was Attorney General, and when Mike Cox was Attorney General, and Jennifer Granholm, we have had to turn those consumers away and tell them, sorry, can't help you. So when I say this legislation is the result of decades of work, I mean it. But today, you have the unique opportunity to help quite literally every single solitary resident of all the districts in this state. And just as so many other states around this country can help their consumers, red and blue alike, just as the Michigan legislature and Governor Milliken in 1976 tried to do, you can help these consumers. So it's time to breathe desperately needed life back into the Michigan Consumer Protection Act, revive the law's original purpose, protecting Michigan residents from unscrupulous businesses by voting to pass Senate Bill 1022. And I'm sorry, I know I've taken a lot of time, but you know, Frank Kelly wrote about this very instance in his autobiography called The People's Lawyer. And if I could just really quickly, and then I'll wrap this up, I just want to read from
Very quickly.
page 113, where he talks about all of his incredible cases that help consumers so much, but that he would be unable to do any one of those things after his time in office because of the change in the law. And he said, today, we need a new Consumer Protection Act with more teeth in it, and we need lawmakers who will stand up for the people. Those lawmakers are you. So thank you very much for the opportunity to be here virtually today. And my staff is there to answer any questions.
Thank you so much for your testimony. Any questions from committee members? No? Thank you so much. Next, we'll move on to Tiffany Ellis, Board Member, Michigan Association of Justice, in support of the bills. Thank you for being here.
Thank you for the opportunity to address you today.
There's actually, I'm sorry, there's a button right at the end of that base of the microphone. Yep, there you go.
Got it. Thank you for the opportunity to be here today. My name is Tiffany Ellis. I'm a partner at the law firm of Piper Wolf. We represent victims nationwide who have been the victims of negligence, fraud, or other misconduct at the hands of powerful interests. Before joining this firm to open a Detroit office, I helped represent 62 Michigan cities and counties, as well as other local governments across the country in the national opioids litigation. To date, and this number is still growing, Michigan and its local governments have recovered more than $1 billion to help fund Michigan communities in our fights against opioids. As you've heard, when the Michigan Consumer Protection Act was originally passed and enacted, Michigan was a leader among states in holding those accountable who torment our citizens with unfair and deceptive acts and practices. As you heard, the former Michigan Supreme Court all but declared the act dead in 1999 in Smith versus Globe Life, and a subsequent decision in List versus Lewiston Richards. Since then, the act has been nothing but words on paper. It's prevented trusted, injured Michiganders, hard-working small business owners, and our state's prosecutors from achieving justice in our courts. We don't have time today to fully examine all the ways that our former Supreme Court undermined this legislature and our people, but know this: these two bills in front of you today pave the way for a safer and fairer Michigan. Section 2A of Senate Bill 1021 and 4A of 1022 restore our elected representatives' true intent to protect our state and ensure a level playing field for our businesses. The crux of these decisions is this: the former Supreme Court said it does not matter that the MCPA explicitly exempts only conduct that is specifically authorized by law. Instead, it's that the general transaction is authorized by law, regardless of whether the specific conduct is allegedly prohibited. The legislature never said general. The court simply added it as a requirement. In other words, under Smith and List, if a business sells goods or services that are authorized by any law or regulation in any way, then all of those transactions, even the ones that are otherwise illegal under the MCPA, are exempt. In her dissenting opinion in List, Justice Marilyn Kelly put it this way: Smith is inconsistent with the languages of a statute in another regard. It permits illegal behavior to be exempt from the MCPA. This is an illogical result. A transaction or conduct that is actually prohibited by law cannot be deemed to be specifically authorized. It's difficult to fully quantify the result of these disastrous decisions. Countless claims against those who have harmed our residents and businesses have been dismissed throughout the last 25 years. Even more were likely never filed. And to your point, Senator Camilleri, here are just a few examples of what that means to Michigan. When the FDA approves a label for a drug, it determines that the label provides enough information for its safe and effective use by doctors for all purposes for which it's intended. But introduction of those drugs into the marketplace for an unapproved use can be criminal misbranding. Let's take the case of drug maker Endo Health Solutions. Endo created and was approved by the FDA to sell an opioid called Opana PR. Endo asked the FDA if it could market the drug as addiction deterrent and resistant to crushing, but the FDA said no. But what did Endo do? They marketed to physicians as crush resistant and abuse deterrent, exactly what the FDA said not to do. And earlier this year, in what was the second largest set of criminal financial penalties ever levied against a pharmaceutical company, Endo was ordered to pay $1.0686 billion in criminal fines, an additional $450 million in criminal forfeiture. Yet under our misguided decisions of the former Michigan Supreme Court, even this conduct is exempt from our Consumer Protection Act. As former Justice Kelly's prophetic dissent made clear, this makes no sense. The MCPA nearly almost stood in the way of Michigan's opioid claims. The only reason why Michigan and our cities and counties were able to proceed is because our claims were uniquely based in public nuisance and RICO, not the MCPA or the product liability actions covered by the former immunity statute. But even in the opioids litigation, several of Michigan local government claims were thrown out due to these distorted interpretations of the MCPA. But it's not all about opioids. Soon after the opioid litigation decision, a federal California judge rejected the Grand Traverse Band of Ottawa and Chippewa Indians claims against Juul under the MCPA for the marketing of their vape products. He relied upon Smith, Liss, and the opioid decision to say that because these products are heavily regulated by the Tobacco Control Act, they are exempt. Previously, homeowners who lost their houses when their mortgage companies said they would not foreclose when loan modifications were being sought had no remedy under the MCPA. Where uninsured patients alleged that they were unlawfully charged the highest and fullest uncompensated cost for their care by hospital, that conduct was exempt from the MCPA because billing patients is a general transaction. Title insurance companies and title agencies that incorrectly charged vendors, other businesses, real estate transfer taxes on the sale of their homes were exempt, and the examples go on and on. As you heard from the Attorney General, she's fighting tomorrow in our Supreme Court regarding her investigatory into price gouging by another drug maker, Eli Lilly. I could spend all day giving examples of how this Consumer Protection Act is that in name only. Simply put, its exemption is harmful to consumers and deprives them of remedies intended by this legislature and provided in the text of the law. But not only that, restoring the Michigan Consumer Protection Act will help Michigan businesses. It's simply common sense that when one company doesn't follow the rules and gains an unfair advantage in profit, it's not just their customers who are deceived, injured, or paid too much who are harmed. All of its competitors, the honest, hardworking business owners who do things the right way, they suffer as well.
Thank you. I do want to leave a little bit of time for any questions, and to move on, we do have actually two more testifiers for this bill package. I appreciate for your testimony today.
Thank you, Chairwoman. If I could just make one more brief point. Contrary to some assertions of those who might be held accountable, this will not lead to an onslaught of litigation. This law was in effect for 23 years before Smith and Liss were adopted by our Supreme Court, and there was no onslaught of litigation against small business owners. Our small business owners will, in fact, gain some rights back under this law.
Thank you. Any questions from committee members? No, I appreciate your testimony today.
Thank you.
Next, I'd like to invite Lori Brown, Executive Director of Michigan Statewide Advocacy Services, Michigan Poverty Law Program, on Zoom with us today.
Good afternoon, Madam Chair, members of the Senate Committee on Finance, Insurance, and Consumer Protection. Thank you for the opportunity to allow me to testify today regarding Senate Bills 1021 and 1022. As stated, I'm Lori Brown, the statewide consumer law attorney with the Michigan Poverty Law Program. And Michigan Poverty Law Program is a statewide support program for legal services. We advocate on behalf of the state's low-income consumers on issues of elder law, public benefits, and consumer protection. Michigan Poverty Law Program is pleased to support Senate Bills 1021 and 1022, which would amend, as stated earlier, the Consumer Protection Act to once again protect Michigan consumers from unscrupulous businesses. The Michigan Consumer Protection Act, as stated earlier, on its face is a very good statute. It currently prohibits a broad range of unconscionable, unfair, or deceptive conduct, such as misrepresenting the terms of a contract, misrepresenting the goods and services of the quality of the particular product, and causing confusion or misunderstanding of legal rights. But unfortunately, as mentioned earlier, because of Globe Life and List, the Michigan Supreme Court essentially gutted the statute and making the statute virtually no benefit to consumers. So all of those prohibitions are basically ineffective because no one can assert those protections. The court interpreted the exemption very broadly so that virtually every type of consumer transaction, such as lending, mortgage, home sales, car repair, home improvement contracts, plumbers, even the hairdresser, because they're licensed and they're regulated, are exempt under the Michigan Consumer Protection Act. It doesn't matter whether that particular conduct is unfair and deceptive, but just as long as it's a business that is licensed or regulated. As legal aid attorneys, we represent hundreds of low-income consumers who are victimized all the time by unfair and deceptive business practices, but are denied legal relief due to the court's erroneous and restrictive reading of the Consumer Protection Act. We see numerous home improvement cases. Oftentimes, we're dealing with seniors who someone comes by and knock on the door to sell them, inform them that they can fix the repair or they can fix the bathroom, install a walk-in tub, and they don't see documents and they don't get the full disclosure of fees, and the home improvement person would not repair do the work or do a poor job of doing that, and also charge twice the reasonable charge for those fees. And in those cases, when the clients come to us, those seniors come to us, we cannot raise the Michigan Consumer Protection Act because the courts, when we do the home improvement contract, would raise the exemption from liability, and the courts therefore would rule that the contractors are exempt from the statute, and we don't have that remedy for the consumers. We also see people who have used car rental agreements with unreasonable, unfair charges. Again, we can't seek relief against those car rental agencies because they're regulated and therefore exempt. And we see many, many more cases from assisted living cases that those agencies, the unfair charges they're charging are regulated, and so they're exempt. And numerous other cases where clients come in to us with problems and we can't get a relief for them. When the Michigan Consumer Protection Act was enacted in 1976, the legislature enacted a very effective statute that would allow its citizens access to justice. With the Supreme Court's decision, the statute no longer meets its original purpose. With the passage of Senate Bills 1021 and 1022, Michigan can once again, as originally intended, allow consumers to defend themselves from bad business practices. So Senate Bills 1021 and 1022 are much needed to protect consumers, and the Michigan Poverty Law Program, on behalf of low-income consumers, supports it and encourages the vote for Senate Bills 1021 and 1022. Thank you.
Thank you for your testimony. Any questions from committee members? No, I appreciate your time. Lastly, I'd like to invite Todd Tennis from Elder Law and Disability Rights Section, State Bar of Michigan, in support of the bills, and I'm going to hold you to your word and time needed at 2 minutes.
I can do that, Madam Chair. So yeah, I'm here. My name's Todd Tennis. I'm here on behalf of the Elder Law and Disability Rights section of the State Bar. And the only reason I'm here is to read a disclaimer, because the State Bar requires voluntary sections to read this disclaimer when we are taking a position. So the Elder Law and Disability Rights section is a voluntary membership section of the State Bar comprised of 1,090 members. The section is not the State Bar of Michigan, and the position expressed herein is that of the Elder Law and Disability Rights section only, and not the State Bar of Michigan. To date, the State Bar does not
2 minutes
have
of
a position. And I will just say that the attorneys who represent vulnerable adults, whether due to age or disability, see quite a bit of deceptive business practices targeted at their clients. And so we would very much support having this law changed.
Any questions from committee members? Appreciate your time. Oh, if you can come back, Senator Huizenga.
I just want to say this is not part of my 2 minutes.
No one's watching the clock, don't worry. I'm curious, if you're representing elders and people that are abused, what kind of work do you have right now if you don't have the tools to do the work as a person supporting elder abuse?
Well, it is essentially when the attorneys that I represent, or members of the section, are generally doing estate planning, or they are doing other work on behalf of their clients, and they will discover that their client had been defrauded by some deceptive practice. And it may be they were defrauded for $2,000. And because the act as it was initially intended allowed for attorney's fees, if you're going after those folks, to be part of the final settlement. Now they aren't, because those folks are exempt from the act. So if one of our members wanted to help their client, who, and I think Ms. Lorraine Brown did an excellent job of describing some of the situations we see, they'd pretty much have to do it out of pocket. They would not be able to be compensated for that unless it was from the client who had already been defrauded. And so they would be spending $10,000 in litigation fees in order to get back $2,000 from the business that defrauded them. And so it's just, it doesn't make any sense. And so the business then basically has no penalty. There's no hammer. There's no justice.
They can be prosecuted, but they can't go for the costs for their attorneys.
In many cases, it's hard to even prosecute. I mean, local, prosecutors are not going to go after a business unless they see a huge, unless they get 50 complaints against the same business, then they might do it. But if it is 2 or 3 complaints that, hey, they were supposed to install this, they didn't, it never worked, they refused to repair it, they overcharged us, that's not going to rise to the level to most prosecutors to actually drop the hammer on them. And so you need the civil litigation system to be able to provide that essentially point of sale justice, and the Consumer Protection Act, as it was initially intended, created that system. And that's what we're trying to get back to.
Thank you so much.
Thank you.
Thank you for your testimony and your time. Thank you, Senator, for the question. Mr. Clerk, can you please read the cards in for the record?
Kurt Berryman, Auto Dealers of Michigan, opposes both bills. Jared Rizicki, Michigan Funeral Directors Association, opposes both bills. Robert Jorg, I apologize, Michigan Laborers supports both bills. Elizabeth Cutter, Michigan Health and Hospital Association, opposes 1021. Dick Van Covering from the Insurance Alliance of Michigan opposes both bills. Amanda Fisher, NFIB, opposes both bills. Wendy Block, Michigan Chamber, opposes both bills. Amy Drum, Michigan Retailers, opposes both bills. Melissa Seifert, AARP, supports both bills. Amy Taylor, Michigan Realtors, opposes both bills. Don Crandall, Home Builders Association of Michigan, opposes both bills. Robert Anderson, Michigan Farm Bureau, opposes both bills. Frank Venuto, American Council of Life Insurers, opposes 1021. Brian Schoaf, Detroit Regional Chamber, opposes both bills.
Thank you. Next, we'll move on to Senate Bill 888 through 892, brought to us by Senator Bayer. Senator, can you please come forward and explain the package? I believe you will be joined by Jason and Ashley from the AG's office, as well as Kathy Fitzgerald, Corporate Oversight Assistant Attorney General's office as well.
Fantastic, thank you. I'll just start and move along as
Yeah.
fast as we can. Because
you
we
have
do have
plenty
some
of
other
time.
folks to speak to us today, too. This is really important. What a wonderful thing to have consumer protection on the agenda today. It's fantastic. So thank you, Madam Chair, and my colleagues for the opportunity to present these bills. The number of data breaches and identity theft reports rises every year. I would wager that everyone in here has either had one or more themselves or know people that have. I personally have had 6 of those breach notifications in the last 12 months, and 2 of them resulted in both mine and my husband's social security numbers be showing up on the dark web. So I got notification because, of course, you have to buy some kind of monitoring service and know that our social security numbers are out there for sale. So thieves and scammers are like this, are on a mission to steal all of our information so they can sell it. They sell it to people who will then use it for their own purposes, buying goods, charging it to our credit cards, buying a social security number to apply for government services sometimes, Medicare, social security, unemployment. We had people in our office after COVID and during COVID who called to say, I can't get help from the state because someone has used my social security number and already applied and gotten unemployment money. So this is happening here already. On average, there's a new identity theft victim in the United States every 2 seconds. This legislation would put Michigan in line with the majority of state laws aimed at mitigating impact to consumers when a data breach occurs. The 881 to 891 will amend the current Identity Theft Protection Act, and I'll give you a couple pieces, but we have other experts coming up here. The bills do add the requirement, it's really mostly about notification to the consumers and to the Attorney General after a breach is discovered and understood. The way things are now, in the 2 cases at my house where our social security numbers were stolen, I never, in a year, it's been a year and a half now actually since that happened, never did get any kind of notice from the company where my data was stolen. I did get a letter from a lawyer, some law firm that they had hired, and I called them and asked to who they were and why did they have my data, take it off their system, and they wouldn't identify. They said, oh no, we're just representing someone else. So well, who is that? And they would not tell me who that was. So I couldn't even find out who it was that stole my data that had the breach where someone stole the data. So, I mean, it's very frustrating as a consumer to have to go through this. And if you haven't yet, you can look forward to that until we get this fixed. So the way the bills work, if a breach impacts over 100 people, the bills require notice to the Attorney General, and they define the information that the AG gets. And 34 states already do this. We are already in the minority here. They also expand the scope of breached information of consequence, so it amends the definition of what is personal information. So it isn't just social security number and driver's license numbers and financial, and now it also includes medical and health information, including genetic and biometric. I mean, we have to keep up with what's going on out there, right? What are the kinds of things that are being stolen? They also require notification to third-party vendors. I'm working on the third-party vendor piece to make sure that everyone, because companies now, especially the bigger the companies, they have all kinds of suppliers. It may be that the actual owner of the data is a different company than the big one that shows up. You might hear some stories here depending on how long things go in testimony, but the big, huge data breach at Wendy's, sometimes the blame gets put on the banker when your credit card, if something happens when you got a breach in your credit card and you call your bank and say, you should pay for that, that was your fault. Might not have been. Could have been somewhere else in the system. So this law has to take care of that and protect the companies as well as the consumers. So we've also had a number of stakeholder meetings on these bills that have been very informative. We have some very good input, and we are looking forward to more of those discussions. And we do have experts here from the AG's office, and we have some other good testimony from people who have been through this. Do you have any questions for me?
Any questions for the bill sponsor? No, thank you.
Thank you.
And I do believe the Attorney General is no longer on. Just curious if you guys wanted to make any comments. Yep, so that microphone is on and that one is not. Ashley.
Good afternoon. Thank you for allowing me to testify in support of Senate Bills 888 through 892. My name is Kathy Fitzgerald. I'm an Assistant Attorney General in the Corporate Oversight Division, and I work on a daily basis just about with consumers who are calling, who are questioning whether or not a data breach notice or letter that they got from a company they don't recognize is a scam, why they're getting it when the letter may say that the breach occurred 2 years ago. These are common problems. And one of the ways that we would like to address this, that would be a common sense measure to help stem this problem, is to permit or to allow, to require, I should say, that the Attorney General be provided notice when a data breach is incurred that it impacts more than 100 Michigan consumers. This legislative fix will amend the existing act to better protect consumers and assure more timely notice to impacted residences. Right now, we're learning of breaches from the media, from consumer complaints to the department, and attorney generals from other states with laws that require disclosure. In some cases, we're learning about a breach months later and after subsequent other breaches have occurred. Consumers turn to the Attorney General to confirm a breach, ask for tips to protect themselves, and firm up their personal data security, and for large-scale involvement on behalf of the people of the state. States that require disclosures, and more than 2/3 in the country do, it's like, I think 37 and counting, receive hundreds of notices per year about data breaches. The Michigan Attorney General probably receives less than 20. We've developed a great relationship with folks in healthcare industry who have been alerting us immediately when something seems amiss, but they're doing it voluntarily, and they are not the only industry impacted by data breaches. In some cases, businesses that operate in multiple states provide notice to attorney generals in numerous other states, but will not in Michigan. And the reason is simply because they don't have to. Which leads me again to the bill. The senator has basically described them, but just to highlight, it would require notice to the Attorney General without unreasonable delay and no later than 45 days after discovery of the breach when it impacts over 100 persons. And it would also spell out the required information that's to be provided in the AG notice. It would also expand the scope of when consumer notice is required by amending the definition of personal information so that it's no longer just limited to 3 different discrete types of data, which is social security number, driver's license, and a financial account information when it's disclosed in combination with a security code or password to access. It would expand it to include medical information, health insurance information, genetic and biometric information, and a few others. It would also require third-party vendor notice to be given to its client immediately following discovery. This would reduce delay that is then given to consumers whose personal information has been provided to the client. It would address delay in notice to consumers by including a deadline, again, of 45 days from the date the breach is discovered, rather than the existing just loose without unreasonable delay, which is a totally basically subjective standard with no criteria. At the same time, however, the bill does maintain a permissible delay beyond the 45 days when it's necessary to discover the scope of the breach or restore the integrity of a computer system or upon request of law enforcement. It would include a duty on the entity holding data to safeguard consumers' personal information. There's nothing in this law that requires that duty now. It would also include a duty for impacted entities to investigate following a data breach. Again, this is not currently required. It would provide the Attorney General investigative authority to compel companies to provide information, which is not present now. This authority is already present in other laws our office handles, such as the Michigan Antitrust Reform Act and Medicaid False Claims Act. The 888 would also authorize the Attorney General to seek injunctive relief and costs and enforcement actions along with the existing civil penalties. In short, this legislation would put Michigan in line with the majority of states' laws that are and is aimed at mitigating the impact to consumers when a data breach occurs. Texas, Alabama, Indiana all have similar AG notification statutes, and that's as part of more than half of the states that require some sort of notification to their Attorney General or Consumer Protection Agency. It's long overdue that Michigan joins these states to protect consumers with a simple solution to a very difficult problem. With that, I'm happy to answer any questions.
Thank you so much for your testimony. We'll start with Senator Huizenga.
Thank you, Madam Chair, and thanks for your testimony. I agree with Senator Bear. I see these things happening all the time. I hear from constituents as well. My questions are merely inquisitive, actually. I've received these notifications, these 4, 5, and 6-page letters that come in and say there's a breach. Are we getting that? It sounds like you said because it's voluntarily that they've chosen to do that independently, or you said voluntarily, and I'm kind of surprised that people would just volunteer something along that level.
No, I'm sorry I wasn't clear. There's no requirement that notice be given to the Attorney General's office.
Okay.
And if they're doing so, they're doing it voluntarily so that we know and that we can respond to consumers who are calling us that get these letters from a company they don't recognize. They say, I've never done business with this company. What is this? And without an AG notice, we probably don't know either, unless another state has told us, or if there's been some media inquiry, in which case we would reach out and try and find out more about it. But receiving notice secondhand and at a later date, after notices have already maybe gone out to consumers, it doesn't help anybody.
So then I guess my other question is, would this be for Michigan-based companies and recognizing the complexity of this because somebody says my data is stored on a cloud in another state? Is this an Interstate Commerce Commission issue? And or how does that work across other states? And then would consumers, if this is just merely a notification to the Attorney General's office, what differences would consumers see in those kind of notifications?
Okay, to your first question, the determining factor of whether a business is covered is whether or not they do business with Michigan consumers, if they have Michigan consumers' data that's been breached. If a company that, say, is multi-state, based in Delaware, has data that belongs to, identifying Michigan consumers that's been breached, then our statute applies. To your second question, and I'm sorry, could you repeat it again? I've lost my train of thought.
If it's on a cloud server, if it's in Michigan, does the data breach, if the breach happens elsewhere? I think you answered it, though. It sounds like it's only if it's a Michigan consumer is affected by this, no matter where that data resides, you'd still receive a notification.
Yeah.
And then I guess the other part is what if the statute were enacted, then would there be changes in the way that the consumers would be notified, or would it still be just all you're doing is just asking for a notification to the Attorney General's office? Is that right?
Okay, as to the consumer notice, it potentially could change because right now notice is required to Michigan consumers only for very discrete types of information: Social Security number, driver's license number, credit card if there's a passcode security code that can access, or financial account, same situation. But for medical information, no notice required. For biometric information, no notice required. It's really a very discrete, limited scope right now. So in that regard, yes, there would be a difference in the notices that are being received, whether they're being received. As to the Attorney General notice, the reason it's important for us to receive them is because if we have information timely and that's accurate, we can then let consumers know and they can take action to protect their data if they've been impacted, or it looks like they've been impacted, could have been impacted. And timing is everything. If your data has been accessed, say your health information, and you don't know about it, then there's nothing you can do as far as taking preventative measures to try and prevent it from being misused, such as putting a freeze on your account, notifying your bank, flagging them that you've been subject of a data breach. And without that, you're just waiting for trouble to happen rather than taking preventative actions to prevent misuse.
So are you saying that there'd be dual notification? The Attorney General would notify people as well as the organization, or would this be replacing it? Or you said that you would notify individuals as well.
Okay, with Attorney General notice, most Attorney General offices that receive notice have a website, And the notices are on a public website, so consumers can go to that website, determine, is my doctor's office affected? Is my car dealer affected? You recall the CDK problem, probably, but at any rate, so there's that search tool. And as well, the Attorney General can and does provide press releases to provide notice to consumers who might not realize that my data could be affected. And again, in response to calls and inquiries, we're able to provide notice and information there too.
Thank you.
No, thank you for the question. Appreciate the testimony, first and last. Thank you.
Thank you.
Question, that is, not testimony. Next, we'll move on to Deshaun Ashby, Director of State Advocacy of the Michigan Credit Union League, joined by Alex Morris, Assistant Vice President of Advocacy at Michigan Bankers Association. Opposed to the bills? Welcome.
Thank you, Madam Chair, Vice Chair, members of the committee. Deshaun Ashby from the Michigan Credit Union League, and my colleague Alex. I didn't realize Vice President was his title, and now I feel very insecure. But before we get into it, I do want to clarify, for the sake of both of our organizations, we are opposed as written. Both of us had very productive conversations with Senator Bayer, and we are all in understanding of how important it is for, on a consumer protection aspect, to protect our data. All of our data is more valuable than all of us in here. So in that case, I will turn it over to Alex a little bit to kind of go through a little bit.
Yeah, well, first, thank you, Madam Chair. Thank you, members of the committee. We will be very brief. You have a full house today. Deshaun kind of alluded to this. We've had a number of conversations, both with Senator Bayer. Thank you for your time on that. We appreciate that. And both of our organizations recognize the importance of protecting data. In fact, we think our members are kind of the gold standard of protecting data. So that is something that we will continue to have conversation on. Thank you for your work on some of the other data breach notification bills that you've had as well. Appreciate that. And we will continue to work on this. We understand that there is some discussion on taking a look at what we would need to do to make this a good policy moving forward. So thank you for your consideration on that.
Just really high level, some of the things that, the concerns that we shared with Senator Bayer. Between both of our institutions being regulated by the NCUA for credit unions and the FDIC for the banks, we have a number of rules and regulations that ensure that we have very stringent guidance and a highly technical infrastructure for making sure that our databases are secure and that we can notify consumers of breaches. One important aspect that I would like to point out in regards to this is the wait for some of these notifications is for us as our institutions to discover both the scope and the risk. That way we're not, giving people inaccurate information, or vice versa. We're not letting people know that, hey, this is going on, and then they freak out, and then it's like, oh, well, it's not, nearly as bad as we thought it was.
Yeah, thanks, Deshaun. Just one other thing I want to add. As we look at some of the federal regulations that our members are under, oftentimes our members are notifying our federal regulators within 36 hours of a breach. So I know one of the important pieces of this legislation and what you're looking at, Senator, is the time frame for notification. And I don't believe that that is much shorter than what you're looking at to provide here at the state. So just keeping that in mind as we move forward. And also just want to make sure that we highlight the importance of the credit unions and the banks being up here together as we walk arm in arm on this issue, and as we do with just about most of the issues affecting financial institutions. So appreciate your time.
And what we're going to largely be looking for here as we continue working with Senator Bayer and the Attorney General on this issue is just clarification as to how this process is going to work. How is it going to work in relation to our reporting requirements to our federal agencies as well as DIPS, and how we can all be more helpful. So we're, again, very much looking forward to continuing to work on this. And any questions?
Yeah, appreciate you both being here and giving your testimony. Any questions from committee members? No? Thank you.
Thank you.
Thank you, Madam Chair.
Next, I'd like to welcome up Claudia Rast, lawyer joined by Daryl English, President, Wolverine Solutions Group. Oh, I think a lawyer for Bussell.
Well, thank you, Madam Chair, for the opportunity to speak to you and the senators here that are assembled and the public. I am a lawyer at Bussell Long based in Ann Arbor. Senator Irwin, hello. And have been dealing with data breaches for many years, since 2004 with California's law. So I bring my daily in the trenches experience with having to handle multiple states as the number of states enacted their data privacy laws over the years until we finally had 50 plus the territories of Puerto Rico, Guam, and the Virgin Islands. And I have sent letters to everyone in all those places over the years. But while the state laws have been with us since California's first enacted its legislation, it took many years for the rest of the states to follow up. And one of the things that I would point out is Michigan was one of the early states that had a data breach law, but not much has changed since. And one of the things about Senate Bill 888 is that it now embodies the best practices that my team have been working on for the last 10 years. So many of the things that I'm reading in this are what we do. And actually, I have had conversations and send letters to Kathy Fitzgerald voluntarily as a courtesy, just because of that same, I think the first instance was 6 years ago when she got letters saying, Ms. Rast, why are we getting letters from you about this and we don't know? I said, we'll come and talk to you. So, I mean, this is really important to bring the state of Michigan back up into what we as lawyers in the cybersecurity field determine are best practices, including the credit monitoring, which is really important. That's a best practice that typically we offer when we send these letters out. And we have states that have no requirements, 12 months of requirements, 18 months of requirements, and thank you, Michigan, for proposing 2 years. Often the timing is really critical. When you have a data breach that includes a Social Security number and it's tax season, it can be really important to have that kind of credit monitoring. And I will point out, in terms of the take-up, we have all gotten those letters. How many have we gotten in the last year? The credit monitoring that's offered is about a 5% take-up activation. So it's offered, but it has minimal ultimate financial impact on extending that offer, but it's an important thing to offer to most consumers. I guess that's really it. I mean, the point that I wanted to make is that we, in the notification issue and dealing with individuals across the country and all the 50 states now that we look at that legislation, Michigan will bring itself up to date with those kinds of best practices. And the one comment about the 45 days, and this is really important, when the data breach happens and when a company is looking at what the chaos that happens, the threat actors don't leave behind Excel spreadsheets with names, addresses, and what they took. It can take weeks, sometimes months, to uncover that. So the fact that you have that kind of language in the statute that anticipates those kinds of really reasonable delays, and that often you include federal enforcement in any kind of investigation is important about that too. But I'll leave my comments to Mr. English here to continue.
All right. Good afternoon, Madam Chair and members of the committee. My name is Daryl English. I am the president of Wolverine Solutions Group. We are a 46-year-old direct marketing company headquartered out of Detroit, Michigan. Our business is primarily made up of two business segments. The first is traditional direct marketing, which you all receive every day. The second piece of it is transactional mail, which involves things like statements, invoices, explanation of benefits on behalf of healthcare companies, payroll applications, policy documents for insurance companies, many things of that such. Our business employs about 200 employees. We have production facilities that span about 200,000 square feet in production space, and we work in industries like healthcare, financial, insurance, automotive manufacturing, and government as well. In fact, we've counted the state of Michigan as one of our clients for over 25 years, and we mail tax documents on behalf of you on an annual basis. On a daily basis, we process about 1 million communications. These communications all contain sensitive information for our clients, and they require same-day and next-day service. This level of processing actually considers us a detached unit of the Postal Service because we do so much volume. The relevance in me being here today is that in September of 2018, Wolverine was the victim of a ransomware attack. Our servers, our data, our backups were all encrypted. The recovery required the expertise for us to bring in outside forensic firms to assist with remediation and help to identify what data was affected. It took several weeks for us to restore data, restore custom applications, and get production running for 350 clients. This data was made up of approximately 10 terabytes of data, which Claudia was nice enough to put that in perspective for me today, that is the equivalent of about 4.5 billion pages of print. That was 30,000 files on 100 workstations, 24 servers, and everything was in multiple formats because we service so many different types of clients. So we had raw data, PDFs, proprietary data formats, everything that you can imagine. We also retained expert cyber counsel with Butts Along, as Claudia had described, who brought us 15 years of experience in the cyber world, and they helped us to navigate through the complexities and the reporting complexities and obligations. As we walked through this process, and as HIPAA requires, we did a timely notification to the Office of Civil Rights. For the states that required notice to attorney generals, insurance commissioners, or consumer agencies, we provided timely notice to them. And we provided notifications to over 1 million individuals by U.S. mail that had private identifying information inside of the data. Approximately 800,000 of those were consumers that are from the state of Michigan. When the Michigan Attorney General Office received complaints from individuals who notified them that they had heard about a breach or that they had received notifications and thought that it was a potential scam, we, through Claudia, arranged a meeting with Kathy Fitzgerald and the Attorney General's Office for Consumer Affairs. During the process of our investigations through the Office of Civil Rights, we supplied nearly 20,000 pages of evidence. We walked through months of Q&A, and during the process of the investigation, we provided credit monitoring to those who requested it. After a 6-year investigation, I'm proud to say that based on our transparency and our accountability for the situation, we were not assessed any penalties or fines due to the attack. Pleased to be here today to discuss the proposed changes for the Michigan Identity Theft Act, and we're happy to provide testimony to assist in the creation of the final format.
Thank you both for being here today and providing your testimony for committee. Is there any questions? Senator Huizenga.
It's a quick one, I promise. Sounds like you do work in other states as well from your mailhouse in Michigan. How does the timely responses compare from the states that you work in compared to what we have in Michigan? And then how did that work from you from an operational perspective to, number one, I guess, identify what the scope was? So notification of breach is one thing, but if you don't know the scope, it's highly complex.
You are correct, Senator. It is highly complex. So to answer the first part of your question, yes, we are a national service provider, so we have clients that are in every state, and we mail communications to every state in the country. Now, to the second part of that question, navigating through the communications that you have to do to individual states, we were fortunate enough to bring in Butts Along, who actually navigated all of that for us and took care of the notifications to the states that did require timely notification.
Can you give us a range as what other states require?
There were about 37, and it varied. But what we did, and it adopted really a best practice in that instance. So our first notification was actually New Year's Eve to the OCR, Office of Civil Rights, which the individual there that we got to know very well. And as we uncovered more, we discovered more data, more individuals, and more states. So we had a number of tranches that continued from December 31, 2018 to March of 2019. We kept track and notified as quickly as we could. Most states had the kind of language that we currently have in Michigan, which is, reasonably post data breach. Others had 30 days, others had 45. We basically did it as soon as we could, given what we had, and basically went with the lowest or the most immediate deadline for everyone. I mean, the problem with when you have multiple states involved is you have to take the most immediate, the most strict standard and comply with that. So it's a process, and you need a really big spreadsheet.
Were you compliant with all the different state statutes for notification date in terms of days?
Absolutely.
Yeah.
Yeah.
Okay, great. Thank you so much.
Thank you, Senator. Thank you for your testimony. Oh, apologies. Senator Rosemary Bear.
I don't have a question. I wanted to thank Daryl for English for coming in today. It was really important testimony. But I also want to mention that Claudia Rast is a global cybersecurity expert. She was the vice chair for the American Bar Association Cybersecurity Task Force. We are extremely fortunate to have her in our state, and working with, of course, the renowned Kathy Fitzgerald as well, to have such incredible talent working on this problem for us is very complicated. So thank you both.
Thank you.
Thank you. Thank you, Senator Bear. Lastly, for this package, Andrew Kingman, President of Mariner Strategies, on Zoom with us.
Hi, good afternoon. Can folks hear me okay?
Yes, we can.
Great, thank you so much. Good afternoon, Madam Chair, members of the committee. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a multi-sector coalition. I also am a privacy attorney with background in privacy compliance and with experience in getting these state data breach notifications out to consumers. We're appearing as neutral today. We met with the Attorney General's office this past winter, understanding that they were looking to undertake this effort. We appreciate that many of the concepts we've discussed have made it into this bill, which I think we agree is due for an update. We also really appreciate Senator Bear's efforts here. We spoke last week. We provided her office a red line of our proposed amendments. And again, look forward to continuing that collaboration with her. Our philosophy is that consumers should get a clear, comprehensive notice stating what happened, what information was compromised, and what they can do to protect themselves. I think you've heard a little bit today about how difficult and complex it is to sort out the different state requirements. And in general, we believe that the more uniformity there is among states and their requirements, the more efficient it is in getting notices out to consumers. And our amendments generally align with these goals. So a few examples of the changes we'd like to see. The definition of security breach uses an access or acquisition standard. Only 5 of the 50 states have adopted this access standard, which we believe is a little bit of an imprecise way of triggering whether an individual should receive a breach notification. There are standards as well that are a little bit overbroad and confusing, whether requiring notice when something may have been accessed or providing notice when a company should have known that there was a risk of harm to the consumer. No other states have these requirements, and it would require, to what a prior witness said, would require consumers to get notices without a business necessarily knowing that a consumer's information has been put at risk. And again, we want consumers to get a clear understanding of what happened and what information is at risk. There are criteria to determine in here whether access was obtained. And again, believe the better standard is an acquisition standard, but not sure that it's the most productive to have prescriptive criteria in a state law to determine whether a breach has occurred. Each scenario is different. Businesses, often I think it's best practice to rely on forensic experts to make a determination about the status of an incident. Certainly don't object to notifying the Attorney General. As prior witnesses have said, that's very standard these days. We've suggested in our red lines to the sponsor moving the threshold to 500 or more affected residents, which is a more conventional threshold, and then removing some of the duplicative material in the notice to make it clearer to the Attorney General's office and just a little bit easier to provide. And we've suggested adding provisions that permit expedited notice for online login information. These are the emails that we receive quite frequently saying there's been suspicious activity. These provisions would allow businesses to notify individuals much more quickly by communicating in the way that they most often interact with the consumer. And we also would suggest incorporating concepts of well-established cybersecurity frameworks. So Michigan would, I believe, be the only state where the breach notification statute outlines criteria for reasonable security procedures. We believe that entities that are using best-in-class frameworks like the NIST Cybersecurity Framework 2.0, the ISO standard, et cetera, should be able to rely on those as sufficient for reasonable security procedures. And additionally, would recommend that Michigan follow Ohio's precedent and provide that such use constitutes an affirmative defense against an allegation of unreasonable security standards. So again, we've given a full set of red lines to the sponsor. We look forward to working with her. We really appreciate her engagement as well as the Attorney General's here. Believe that the statute is due for an update, and I'm happy to answer any questions.
Thank you so much. We're actually going to move on. I appreciate your testimony. Can the clerk please read in the cards?
On 888 alone, Marcus Keach, Grand Rapids Chamber opposes. Kate Dorsey, Michigan State Medical Society opposes. Wendy Black, Michigan Chamber opposes. Amy Drum, Retailers Association opposes. Tyler Deers, TechNet opposes. On the package as a whole, 888 to 892, Brian Schoaf, Detroit Regional Chamber opposes. Joshua Lunger, Grand Rapids Chamber opposes. David Worthams, Michigan Manufacturers opposes. Kelly Saunders, Small Business Association opposes. Amanda Fisher, NFIB opposes. And Kurt Berrybin, Auto Dealers of Michigan opposes.
Thank you. And lastly, we're going to move to Senate Bills 954, 955, and 956, introduced by myself and Senator Moss. We'll also pass the gavel to my Vice Chair, Senator Irwin, during the testimony.
Thank you, Chairwoman Cavanagh. Thank you, Vice Chair Irwin.
Senators, thank you.
Oh, okay, sorry. You know, the chair told me I could speak, I could start. So.
Senator Moss, if you'd like to kick us off.
Thank you, Vice Chair Irwin, for recognition, and thank you, Chair Cavanagh, for hearing the testimony on this bill, on these three bills, actually, that we've introduced. I've waited 7 years for this committee hearing. I have no issue waiting, another hour to get these on the agenda. And really, I think it's very timely that we're having these hearings today as other states are dealing with and reeling in the impact of Hurricane Helene, and as Florida is bracing for Hurricane Milton. These states have declared emergencies during which they have restricted action on price gouging. Now, we obviously don't have hurricanes here in Michigan, but we do have extreme weather events like winter storms and summer flooding that we have to protect our consumers here against price gouging. Unfortunately, we do not have the same laws that are enacted right in this very moment in those states with declared emergencies. So this actually was brought to my attention back in 2017. We had a historic windstorm here in March of 2017. Which was actually hurricane equivalent winds, and it knocked 1 million people in the state of Michigan out of power. And during that time where many people were displaced, I was a state representative at the time, and we got a call in my office of somebody flagging that there was a hotel in Southfield, my hometown, that turned off its neon sign that said $59 a night and ended up charging rates of up to $400 a night while people were displaced and they were out of power. So I called the Attorney General at the time and found out how feckless and toothless our price gouging law was to be able to investigate that claim and even pursue remedies for the people that were aggrieved during this particular storm. And it's unfortunate that we had a business and that there are businesses that would want to profit off of that type of human misery. So we found out that 34 other states, including the District of Columbia, have a price gouging law. And Michigan does have a price gouging law, but unlike the other states with the price gouging law, we don't have a trigger specifically on what a business cannot do to exploit consumers during a declared emergency. So flash forward to us trying to work on legislation to remedy that. We had Attorney General Nessel come into office, and we were working hand in hand in 2019 on updating Michigan's law to catch up to the rest of the country, and then the COVID-19 pandemic hit. And I think we all were very aware of price gouging during the early part of the pandemic. And it was the framework of our drafts that we did introduce at the very start of the pandemic that Governor Whitmer utilized for an emergency order to curb price gouging during the early part of the pandemic. And it worked. It safeguarded Michigan consumers from unreasonable price increases during the pandemic. And sadly, the ability to prevent this kind of profiteering off of the backs of those in need is no longer available because those provisions have not been codified into law. So I do want to note, and this is really, really important, that the vast majority of hotel operators and retailers and grocery stores and energy companies are not engaging in this type of behavior. But the actions of a few bad actors can cause all Michiganders to worry that in a time of an emergency that they might be exploited and taken advantage of, and that we here have a responsibility to protect them. So this is what this legislation does. It joins the 34 other states that when there is a declared emergency, this law triggers during that period of emergency that prevents bad apples from spoiling the whole bunch. In 2023, here in Michigan, the governor issued 6 state of emergency declarations resulting from floods, tornadoes, and severe storms. And the need for this legislation is ongoing and will not lessen over time. So we have here 3 bills that we're very excited to bring forth to the committee with the full backing of our Attorney General's office. One dealing with hotel and lodging, one dealing with retail supplies, emergency supplies, and essential needs, and one dealing with energy products. So I will turn it over to a very willing partner in the chair of this committee, and I'm very appreciative of her support and partnership, Senator Cavanagh.
Thank you, Senator. And thank you momentarily, Chair Irwin, committee members, and again, Senator Moss, for your leadership on this package for so long. I was very excited to enter in the legislature and also join this fight. Excessive pricing and price gouging are issues that we've witnessed for far too long, and community members feel the pinch in their pockets as costs continue to soar. During times of crisis, we've seen companies take advantage of the needs of their products, raising prices to unjustifiable costs. In fact, as we heard from Senator Moss's testimony, we saw price gouging complaints in Michigan from 2019 to 2022 rise by over 4,000%. My bill, Senate Bill 956, will prohibit grossly excessive price gouging for energy products and services and increase the violation and penalties for it. When energy costs are already unaffordable for many of our residents, a state of emergency is the last situation in which we should ask residents to pay more. This legislation provides basic consumer protection that every Michigander deserves, that we've been hearing so prevalent in this committee hearing, preventing businesses from exploiting consumers. And as we heard, it's not every business. Let's not make the bad actors of the businesses overshadow all of the good. So with these changes, we are sending a clear message about the values of our state should uphold around consumer protection and also giving the government the tools necessary to take on those bad actors. Thank you, Vice Chair and committee members and Senator Moss for allowing me to speak and be a part of this package today.
Thank you, Senators Cavanagh and Moss, for explaining your package to amend our feckless and toothless laws around price gouging. Do any members have any questions for the sponsors? Yep, Senator Heisinger.
Thank you, Mr. Chair, and thank you both for your testimony today. Question is how do we define what is grossly in excess? And then secondly, is this only during an emergency time period? Because I know oftentimes people, when they come to my office hours, will complain about the price of eggs or the price of gas, and some of these things that are truly like based off of the commodity driven nationally, like avian flu happens, and so the price of chicken goes up and eggs go up. So two, how do we define what is gross, and then is this only particularly related to situations in emergency declaration by the governor for the particular area?
Yeah, we're talking about an unjustified disparity of more than 10%. And I can talk about that. And then the state of emergency would be a declared emergency, either natural or man-made disaster, or an emergency resulting from a tornado, earthquake, flood, fire, riot, storm, act of war, threat of war, military action, or period of instability following a terrorist attack or threat to the public health for which a state of emergency is declared by the governor under the laws in this state. And then that 10% disparity, we looked at states around the country. Again, 34 other states have this trigger, and it's during that period that the emergency is declared. And states have a range. 2 states do not have any price increase. 7 states plus DC have that 10% threshold that we're looking here. 4 states, 15, 1 state between 5 and 15, 1 state at 20%, 2 states at 25%, and then 19 have it undefined. And so that, I guess, would be a case-by-case basis, could be any price at all. So we're kind of in the middle of that range, and we're joining with where most of the states are in that 10%.
Yeah, and if I can also add, there is a caveat as far as person selling or offering the energy product or service can demonstrate that that increase in price is because an increase in cost that provided that product, or the price before the market disruption was an extraordinary discount. So there's also an opportunity for that seller to show that there's cost associated with that price increase.
Great, thank you very much.
Thank you, Senator Heisinger. Thank you, Senators. My time as temporary chair is now ending. But I will enjoy the moment while Senator Cavanagh comes back up to reassert her control over this committee. Thank you.
Thank you, Vice Chair. Such chaos. Let's get back to order. I think lastly, to testify on these bills is Ashley and Jason from the Attorney General's office. Joining us for the whole committee today.
You guys did such a good job here that we're just, batting cleanup on these ones. Go ahead, Jason.
All right, want to start? Good afternoon, Chair Cavanagh, members of the committee. Thank you for allowing me to testify today in support of Senate Bills 954 through 956. And thank you to Senator Moss and Senator Cavanagh for introducing this important package of bills. My name is Jason Evans, and I'm the Division Chief of the AG's Corporate Oversight Division. Collectively, these 3 bills are common sense, widely adopted measures to strengthen consumer protections against excessive increase in prices or price gouging on essential supplies, services, and lodging during an emergency declaration, and on energy products like gas and propane during a market disruption. Price gouging is an exploitive practice, especially during emergencies when consumers are most vulnerable. And obviously, the bills have been explained, and Senator Moss sort of opened the door for this. One of the things I wanted to mention is, we're seeing a real-time example of why these bills are necessary right now, right? In Florida. Florida just got hit by a hurricane, and much of the Southeast got hit by a hurricane, and now Florida is hours away from its West Coast taking another hit from an potentially even more destructive hurricane. So what I wanted to point out is that Florida, which has a law like this, has already instituted that law. And I've got an article that I printed off today from USA Today. It said, Florida Attorney General Ashley Moody has received more than 200 complaints about price gouging, as many thousands of residents prepared to evacuate from Hurricane Milton. As of Monday, most of the complaints are about fuel and water, said Kylie Mason, Moody's spokesperson. There were also scattered instances involving overnight accommodations, including one Airbnb listing of a room in Tallahassee for nearly $6,000 a night. Our team already reached out to our Airbnb corporate contact and tracked down the owner, Mason said. We are sharing a copy of the price gouging statute and making them aware of their legal responsibility. So Florida had instituted, the Attorney General and the Governor instituted their price gouging hotline, which they put into effect anytime that there's a declared emergency, because of the concern about the unscrupulous folks who move into areas after a storm devastates that area, right? So Florida understands this. Florida understands this probably better than most any other state because they get hit by extreme weather so often. But obviously we do in Michigan, maybe not on the sort of the global scale that Florida does, right? A lot of times our emergencies are more isolated. But these are, this is the type of work, and it doesn't matter what state you're in, the politics of that state, but this is the type of work that that attorneys general around the country need to be able to do to protect consumers. Because although many, many, many businesses are going to do the right thing after these storms, help their fellow citizens, there are going to be unscrupulous folks who realize this is a great opportunity for me to make a lot of money, because people need things like these emergency supplies that are going to be in short supply. People need things like a room to stay in because their families have no place to stay. So why don't I take my Airbnb? I have a short-term rental in northern Michigan, right? And the concept of making $6,000 a night, boy, that would be really attractive. But to do this by victimizing folks who need a place to stay, whose home may be destroyed, is terrible. And this is why these types of bills are necessary, because it's important for us to be able to protect our fellow citizens when stuff like this happens. So since the bills have already been described, I don't want to sort of get into that. I just want to really stress, because again, we're seeing in real time why these are needed, why our office supports these bills. Thank you, and I'm open to any questions that the committee may have.
Thank you for your testimony. I am not seeing any questions, so I appreciate it.
All right,
Thank you so much. Will the clerk please read in the cards?
On 956 alone, Pete Langley on behalf of Marathon Petroleum and the Michigan Petroleum Association opposes. Amanda Fisher, on the entire package of 954 to 956, Amanda Fisher, NFIB opposes. Leah Robinson, Michigan Chamber opposes. Marcus Keach, Grand Rapids Chamber opposes. And Brian Schoaf, Detroit Regional Chamber opposes.
Thank you. And with no further questions and no further business, without objection, the Senate Committee on Finance, Insurance, and Consumer Protection is now adjourned.